Yes, I may say assist your lordship.
How many matters are there?
My lords, today there are a total of 5 matters. Item numbers 10 and 13.
Which is the lead matter?
My lords, I don't propose to take, or any matter can be treated as lead matter, or SCA 3723 of 26 has pleadings completed.
My lord's lead matter is SCA 3005 of 2026. That is the main matter. But reply and rejoinder, if I have to argue, my notings are in SCA 3005 of 2026.
Sir, that may be treated as lead matter. No problem.
For reply and rejoinder, we give separately to this honorable court.
Reply and?
The reply and rejoinder, not much is said. They have said that expert committee was formed, and therefore now the decision is final. We have
going to say the pleadings are fully completed, and there is an order of the honorable coordinate bench that the record of 3723 of 26 can be treated to be the reply and stand of the state in all matters. Well, if with your lordship's permission, I need 2 minutes before the petitioners begin.
All right, about
3723 of 2026.
3723 above.
Well, then there is one more matter. In fact, by the same order, I was also extended the benefit of the interim order. But my matters, my lords, is not listed today.
All right, we'll see when.
Please, lords, just to point out.
My lords, in 2 minutes, just to lay down the bag. My lords,
Let the file come.
please, I'm sorry.
This one.
3723.
My lords, I don't propose to take your lordship to the document. Admitted facts. My lords, we are concerned with an examination called the TET, Teachers Eligibility Test, TET. The framework that the state government follows is that TET and qualification therein becomes the basis of appointment as vidhyasahayak. So after TET, you need nothing more. Based on your past scores, so your 10th, 12th results plus your TET, you become vidhyasahayak. Now, why did I have to mention the matter today morning? Well, we came out with an advertisement for 11,000 vidhyasahayak posts. 11,000. These would be primary teachers teaching from standards 1 to 5 in all government schools.
Primary teachers.
Primary teachers, my lords, from standards 1 to 5. These are not subject-specific appointments. So the teacher teaching Ganit will also teach science, will also teach English, except language. So English, Gujarati, mediums alag hoise. Well, our state's teacher to pupil ratio is 1:3, 1:25. So for every one teacher that I have in my primary school, I have about 25 students. Today, as we speak, we have a vacancy of about 17,000 Vidyasahayaks. And I have a 10-year recruitment calendar already lined up. Avta varshe sir, in calendar year 2027, I already have committed to the world at large. I will be inviting 5,000 more people to become Vidyasahayaks. Now, in that background, what is the, in 1 minute, the dispute? Well, I took the exam of Teachers Eligibility Test, TET. That advertisement happened, advertisement is dated 14/10/2025, Lordship. And it is at page 14/10/2025.
For TET exam.
TET exam, my lords. It is at page 52 of Lordship's record. My lords, the exam took place on 21/12/2025. And 91,628 candidates appeared. So, my lords,
Yes.
subsequently, I received about, my lords, there is always an objection window. સવાલ તમને ગમ્યા ના હોય, તમારા પ્રમાણે ખોટા હોય. I received around 10,000 objections for about 91 questions. It's all stated in my reply. And so I formed a 5-member expert committee and they delivered a finding. Now, what was that finding? I don't want to save myself. Please only turn to page 12 for a moment of the matter before your lordship. Para 11. So that lordships have the version of the treatment given by the state on these objections. Para 11 at page 12 of the pleadings. With lordship's permission, the petitioner states that on 17/1/2026, the respondent board, that is the primary education board, my lords, released the final answer key FAK for paper series A along with question paper in series A in English, Hindi, Gujarati. સાહેબ હવે આ મેં મારા 5 સભ્યોની કમિટીની ટ્રીટમેન્ટ. In the FAK, grace marks were awarded for 3 questions, being question number 21 owing to print mistake in the question paper of Gujarati medium, question 72 owing to print mistake in the symbol in the question, rendering all 4 options incorrect, and question 105 owing to all 4 options being incorrect to candidates across all 3 mediums. Further, with respect to paper series A in the English medium, the answer to 7 questions being so and so were revised by declaring more than one option as correct. Similarly, in paper series A of Hindi medium, answers to 8 questions were revised by treating more than one option as correct. And in paper series A of Gujarati medium, the answer of 6 questions were revised on the same basis. So, sir, basically, I gave some grace marks. In some questions, I treated all answers to be correct because that symbol may have been typed wrongly by my typing. On the basis of that, I published final answer. After I published final answer, and after that original objection window is over, this petition and this batch of matters, one after the other, come up by around 650 to 700 students. So before your lordship, in these 5-6 matters, 5 today and one of 3 Matthew possibly coming to, there are about 650 to 700 students out of 91,669 who had participated. And would your lordship please like to oblige me by seeing the interim direction that the Honorable Coordinate Bench released on 23rd April 2024 of the orders. April 2024. Please oblige me by turning to paragraph number 15, the last paragraph of the order, the operative direction. Because as I understand from the learned AGP who assisted the Honorable Court at that stage, there was extreme paucity of time. This was all just before the summer vacation. In view of the above, just to ensure that these petitions may not become infructuous, and when the petitions are pending consideration of this court, it may not result in a futile exercise. The respondents are directed to allow the petitioners to participate in the ongoing recruitment process for the posts of primary teachers pursuant to the advertisement dated 1/4/2026 on the above conditions. Above condition એવી છે કે પારા નંબર 13 અને 14 માં કે આ અંડરટેકિંગ આપશે કે કોઈ રાઇટ ક્રિએટ નહીં થાય અમારા ફેવરમાં. If due to any technical reason, it will not be possible for the petitioners to make the online application as the last date of is 24/4, that is tomorrow. In that case, the respondents are directed to accept physical application. So, my lords, by way of this interim order, Honorable Coordinate Bench tells me, forget the passing marks. All petitioners before your lordships are without passing marks. The grand case of all petitioners is after the cutoff date for raising objections and inquiry comes in 5-member committee and grace mark, that they dispute 18 questions. And they say that if our version of answers is considered in all 18, we get at best 18 more marks, in some cases 5 more marks, so on and so. I have 91,000 candidates. My next step is publishing the merit list of Vidyasahayak. There is no second exam. So although the Honorable Coordinate Bench possibly passed this order in anticipation that there will be another possible process that may happen, there is no exam. So sir, now how do I make the merit list of Vidyasahayak? Sir, 50% હું જો 12મા ધોરણ સુધીનો મેરિટ અને 50% માર્ક્સનો વેટેજ હોય આ TET ની પરીક્ષા. Now the catch-22 that I am in, and then one judgment of the apex. The catch-22 that I am in is that if I were to comply with this direction of the Honorable Coordinate Bench, then Mr. Gursharan Virk, who is a candidate who has failed in TET and in ordinary course is rank 60,000, has to be factored into as treated to be passed and figure in the merit list. Not just that. There are only 600 petitioners before your lordship, but there may be around 30,000 other similarly situated students who also have to be given the same treatment, or else I am creating a separate benchmark for people who can afford litigation and separate benchmark for people who cannot. So somebody who is ranked 21,000 will suddenly have to still be considered into the merit list by treating him to have passed, which is impossible for. Actually, this should have come from the state when the interim order was passed. Let me be fair to the Honorable Coordinate Bench and to this Honorable Court. Be that as it may, before I show the one judgment which covers my view and the judgment of the Coordinate Bench which takes the same view, my suggestion today is something different. I have 17,000 vacancies today. Please record my statement. In the next calendar year, said મારા 10 વર્ષનું recruitment calendar is already out. I already have committed કે હું 5,000 બીજી વિદ્યાસહાયકની જગ્યાઓ ભરવાની. Today, total applicants for vidhyasahayak are 10,159 people, plus the present petition. It is impossible for me to create a merit list for vidhyasahayak by factoring these petitioners as having been. But at the same time, my lords, my schools are suffering. The vacancy is 17,000. The children do not have adequate teachers to be taught. Please forget quality of education. 17,000 vacancies. This was a plan to fill up everything in the next 24 months. This is the roadblock it has hit because about 650 people come and say, no, answer A is not correct, answer B is correct. Now, on this very simple issue, the Honorable Apex Court is more than submitted. And then I need to show only one decision of our Honorable Court. Would your lordships please oblige me by having paragraph 30 at page 368 of the report? Bottom of the page, para 30. The law on the subject is therefore quite clear, and we propose only to highlight a few significant conclusions. They ask, because 30.1 does not concern 30.6. If the statute, rule, or regulation governing an examination does not permit re-evaluation or scrutiny of an answer sheet as distinct from prohibiting it, then the court may permit re-evaluation or scrutiny only if it is demonstrated very clearly. Now, this is important. Without any inferential process of reasoning or by a process of rationalization, and only in rare and exceptional cases that a material error has been committed. The court should not at all re-evaluate or scrutinize the answer sheets of a candidate. It has no expertise in the matter, and academic matters are best left to academics. The court should presume the correct of the answer key and proceed on that assumption. In the event of doubt, the benefit should go to the examination authority rather than the candidate. On our part, we may add that sympathy or compassion does not play any role in the matter of directing or not directing re-evaluation of an answer sheet. If an error is committed by the examination authority, the complete body of candidates suffers. The entire examination process does not deserve to be derailed only because some candidates are disappointed or dissatisfied or perceived some injustice having been caused to them by an erroneous question or an erroneous answer. All candidates suffer equally, though some might suffer more, but that cannot be helped since mathematical precision is not always possible. The court has shown one way out of an impasse. Exclude the suspect or offending question. Sir, we have done that. It is rather unfortunate that despite several decisions of this court, some of which have been discussed above, there is interference by the courts in the results of examination. This places the examination authority in an unenviable position where they are under scrutiny and not the candidates. Additionally, a massive and sometimes prolonged examination exercise concludes with an air of uncertainty. While there is no doubt that candidates put in tremendous effort in preparing for an examination, it must not be forgotten that even the examination authority has put equally great efforts to successfully conduct an examination. The enormity of the task might reveal some lapses at a later stage, but the court must consider the internal checks and balances put in place by the examination authorities before interfering with the efforts put in by the candidates who have successfully participated in the examination and the examination authority. The present appeals are a classic example of the consequence of such interference, where there is no finality to the result of the examination even after a lapse of 8 years. My lords, now, because it is slightly more descriptive, the view taken by our honorable court, the honorable coordinate bench, the recent decision, because I appeared, I may say it was virtually identical. The facts were virtually identical.
Interim
No, no,
order
my
versus
lord,
final order.
in fact, my lord, there was a major difference, my lord. I will
Mr.
point.
Yes, your turn will.
Yes, yes.
My lords, virtually identical. The entire matter revolved around challenge to questions and answers. This is what is happening here. Obviously, the question and answers will not be the same. Please see the view that is taken by the honorable coordinate bench at paragraph 8.8 of the judgment. 8.8, lordship. The honorable coordinate bench is kind enough to discuss the entire law, including consider Ranvijay. Paragraph 8 onwards are all judgments, which I had cited, which I will cite before your lordships. And para 8.8. Lordships may take it that para 8.1 to 8.7 are my arguments. If the decisions cited by both the sides are taken into consideration together, it would indicate that while exercising powers under Article 226 of the Constitution of India, this court has very limited jurisdiction scope to reevaluate the answer sheets, more particularly when the answers are already reevaluated by the experts, since the same would amount to sitting in appeal over the reevaluation done by the experts, which is not permissible. Further, even if there is some minor error or incorrectness in the answers provided in the answer key, it will not only be to the present petitioners who would be the sufferers, but all other candidates would also equally suffer the same on account of such an error or incorrectness in the answer key, and for which I emphasize, only in case the experts opine that a particular question answer was incorrect, it is always open to the examining body to cancel the particular question answer and to give necessary marks to all the candidates who had attempted such a question on a pro rata basis. In the instant case, even the experts have not opined that any answer suffer from defect, incorrectness, and therefore the exercise of aforesaid option is out of question. And finally, the petition was dismissed. Since my friend Shri Vyas is contesting that this case was slightly different, let us please recall and review the facts. Please oblige me by coming to paragraph number 4 of the petition, the prayers. Here, it was the Gujarat Subordinate Services Selection Board that had published the final result. Paragraph 4 reproduces the prayers, my lords.
Where are you reading?
My lords, para 4 of the judgment of the Honorable Coordinate Bench.
Yes.
And please see the nature of contest, paragraph 6. Let me read what Shri Vyas argued.
Just a second. Paragraph 6 you want?
Paragraph 6 at bottom of page 6, my lords.
Yes.
Learned advocate Mr. Vyas, appearing for the petitioners, who have challenged 23 questions in these petitions, out of total 37 questions, which were subject matter of challenge of so and so, made the following submission. Sir, I'll quickly read the submission. The questions which are subject matter of challenge and for which revised answer key was provided by the concerned respondents are such that even revised answer key appears to be incorrect. Exactly their case here. They will try to show by an inferential process that Ranvijay, Honorable Apex Court, disapproved that somehow the answers are incorrect. And two, the revised answer key not only contains incorrect answers, but certain questions were out of syllabus. And therefore, the court may either refer those questions to committee of experts. In this case, the committee of experts, the state itself referred. Now, therefore, my lords, there are 4 other judgments, but they lay down the same proposition. I only want to make one submission because of the desperation that the state faces today. 7,000 teachers vacant. I would have 17,000. I need to fill up 11,000 by this recruitment, 5,000 more come next year. None of the petitioners are going to miss the bus. 5,000 new posts next year. Number 2, the petitioners have come after the entire exercise was over to challenge an exercise that the Honorable Apex Court says the Honorable Writ Court must never interfere in. Therefore, I have to only make in rejoinder after my.
So what is it? What is under challenge is the final answer key.
Final answer key.
But that can be only challenged when it is published.
And 18 answers. It was published by us. And 18 answers.
No, it can only be filed after it is published.
I bow down. But when was it published? It was published in January.
And when it was filed, petition was filed.
Petitions were filed in April.
No, my lord. I filed the petition in February.
February, but interim relief is granted in April. From February to April, nothing has happened.
Because the advertisement for filling up the
Vidhyasahayak scheme.
was published on 1/4/2026.
Now, my
Thereafter, on 7/4/2026, we filed a civil application for interim relief. It's
So
not-
now my
it's not
submission
coming
to your
back.
lordships. My lords, on law, the Honorable Apex Court and our Honorable Court are clear that no interference in getting into an inferential process of seeing whether the question and the answer match. The state's decision is final. But my lords, I have an alternate respectful submission to your lordships. Sir, 11,000 જગ્યાઓ માટે આ advertise ના હતી. I have 10,159 candidates who are actually qualified. So I have about 990 posts which are vacant. And I have 5,000 more posts line up in 6 months' time. Let the petition remain pending if they want to argue for hours at end. Let me please modify the interim, please modify the earlier order, and let me at least make appointments for 10,000 Vidhyasahayaks. It is in the interest of the children of the state. If they are not agreeable to this proposal, I leave it to your lordships to take a decision. But on law, there are 30 judgments of the Apex Court, all considered by the Honorable Coordinate Bench in the decision I read out, which takes a view that this cannot be interfered.
If supposingly, if they are agreeable, supposingly, and tomorrow they succeed, then what is the position? For
Let us tell.
already the appointment that you are made.
There is going to be absolutely no problem. Why? Number one, I see a very bleak possibility that they succeed because they will be succeeding against Apex Court's decisions. But let us still take it that without getting into it, I have read the petition word by word. Without getting into an inferential process, the Honorable Court still comes to the conclusion the question answer khota chhe. They have already given an undertaking that they are not going to claim equity. I will appoint 10,000 Vidhyasahayaks today. I will have the authority, I will have adequate vacancy. 7,000 તો સાહેબ અત્યારે છે લોકો રિટાયર થશે 5,000 હું આવતા વર્ષે લેવાનો છું એવું મારો કમિટમેન્ટ છે it may be recorded. I am carrying the recruitment calendar and I have instructions from the highest authority of the education department. Let us say they succeed 4 months from today and in November 2026 they are directed by a mandamus to be considered for appointment as Vidhyasahayaks. 1,000 જગ્યાઓ ખાલી જ પડી હશે સાહેબ આ રિક્રુટમેન્ટ. સિનિયોરિટીનો પ્રશ્ન એટલે નથી આવતો કારણ કે એ લોકોએ ઓલરેડી અંડરટેકિંગ આપેલી છે. They will be considered. But let the children of the state not suffer because of a litigation filed by 700 out of 91,000 candidates. That is the only request I have to make. I have 4 more judgments that I could have cited, but we must be responsible.
Let me understand.
Their perspective. But I am arguing in a very fast manner because we have to be responsible when we argue before a court that has so much burden. That is all.
Yes, this appears to be for 1,000. We can consider 10,000. Let them.
Not not
Mr. You are the petitioners. Those have approached here.
Please not.
650 or 700.
Please not.
their interest is protected. Let that 700 post be kept vacant.
Lord, even otherwise that are going to be vacant for the reason that, Lord, the state
And
government
ultimately-
does not have. Lord,
Ultimately, Mr. Vyas,
please, Lord.
if today your candidates required number is kept vacant,
Please, Lord.
what is the problem?
But the,
It
there is
appears
as-
absolutely equitable.
Lord, there is as such no problem, Lord. But
No, but I clarified that. If it is not by, I'm clarifying in your favor also.
no, the difficulty for us would be that, Lord, this petition.
Mr. Vyas, let them 10,000 be filled in.
No, we
There is
cannot have.
ultimately, as she's rightly said, there is no bar, but clarification is in your favor otherwise. On his statement, 1,000 posts are to be kept vacant against
There are only 764 petitioners. Please keep 800 posts.
800 posts to be kept pending.
764 अच्छे petitioners.
Oh, there is no difficulty, Lord. But the difficulty,
Then
there would be a hard burning, Lord.
happening for what? Your petitions are under consideration.
Please, Lord.
But for that 11,000 posts
No,
can't
no,
be
certainly not, Lord.
kept on waiting.
ના, ના, એ તો થઈ જ ના શકે, sir.
Our request is that even the interim order, it says let us participate and there is no bar.
But
on-
there is no further participation. Now it is a question of only appointment orders,
Yes.
as I understood.
Yes, fine.
Yes, sir.
No new exam.
Yes, but they will have to prepare a merit list. Let them prepare a.
How can
provisional
I
merit.
do? A candidate who has failed,
No, no,
not
no.
secured minimum.
One
ranks
minute,
190
one minute,
19,000.
let me,
How can he be brought
let
up?
me answer. As far as those candidates who have passed, because some of the petitions here are filed by past candidates as well. So they may prepare a merit list of the past candidates and prepare a separate list of the petitioners which are before this honorable court. At least that process can be undertaken. We are not here to stop the recruitment process. That is not even our prayer. As far as preparing the merit list is concerned of the past candidates and determining the cutoff marks is concerned, they may start the process. There is no bar in preparing the merit list.
But then it will be amounting to, in a piecemeal things. Let it be with the clear understanding. Let this first 10,500 posts to be filled in first. Let it be. So far as your petitioners are concerned, who they are approached here, for them, we are keeping post vacant
But my
for
lord,
this recruitment process.
my lords, we are not objecting to that. For a minute, my lords, it may not be taken as if we are objecting to the order that is proposed to be filed. Our only suggestion is that for giving the appointment, a provisional merit list will have to be prepared of the past candidates. They may do that. After that, they will have to prepare our provisional merit list as well, but we will not claim any appointment because that is part of the order. We have said that we will
Why
not
that
claim,
exercise to be undertaken?
because it is part of the order, my lords. The earlier order that is.
Let us
passed-
see.
Yeah.
Well, before Lordships reads the order, till these 18 disputed questions and alleged one or two or three or four or up to 18 marks are not added, how will I determine where these people figure in the merit list? Let my friend explain. Sir, 1 થી 18 સવાલો ખરાબ છે. My friend's best case is 18 ખરાબ છે, રાજ્ય સરકાર ખોટી છે. My friend's worst case is 0 ખરાબ છે, રાજ્ય સરકાર સાચી છે. સુપ્રીમ કોર્ટ રાજ્ય સરકારનું મત લે છે. Settled law છે. How do I determine how many marks to give these 764 petitioners till this petition is not decided? She wants to take the shield of the interim order of the Honorable Coordinate Bench. The interim order of the, I must be fair to the Honorable Coordinate Bench. Possibly the Honorable Coordinate Bench was not communicated either by the state or by the petitioners that साहब कोई स्पर्धात्मक परीक्षा હવે નથી. It is just a question of preparing of list. જો એવું Honorable Coordinate Bench માં કહેવામાં આવ્યું હોત, તો આ order થઈ જ ના શકે.
We had made that statement before.
My
this honorable
suggestion
court.
is, if they are so eager to conduct
Alright,
the matter
Mr.
finally,
Let it be that your 700 posts to be kept pending, vacant.
Please,
Sorry.
my lord, just to clarify on how weightage is to be given, this is a convenience note that was prepared by us. My lord, kindly see item number 3.
Yes,
Yes, now this is the weightage that is given. So once the screening test, that is TET, is undertaken, this is how they give the weightage. So as far as the difficulty of my learned friend is that how will they give us a weightage for TET 1 is whatever marks are given, 50% may be added. Now I'm not saying merge me with the past candidates. I am saying for the convenience, overall convenience of the court and future proceedings, prepare a separate list. This is only maths. If I have scored 80 marks, all they have to do is calculate 50% of TET 1 mark.
And your scoring of marks would be subject to your that 18 questions.
અત્યારે જેટલા આપ્યા છે એ પ્રમાણે ગણી લો. અગર હું પાસ થાઉં, if some of the questions are corrected, then they will have to be added. Because the court, the order, let us see the order that is passed. by
About
this
other similarly situated people
But they-
similar to the petition.
But they have not come before this honorable court, so they are not
There are
supposed to
about
do anything.
40,000 more people situated. If I have to factor even one question out of 18 to be interfered.
અત્યારે તો ક્યાં કરવાનું છે?
Opening- In fact, this order will create a heartburn and create an unfair assumption in part of all people who will
But my
suffer.
lords, they have not come before this
Because
honorable
I am
court.
coming with a very fair suggestion that has not been easily digested by the state. But it is on my advice that the state has accepted it because this. And I am suggesting 27 તારીખ sandwich day છે, કોઈ નહીં આવે. Let the matter be finally argued at 2 August. Let it be argued on that day.
ના ના એકલું
Argue કરીને પતાઈ દઈએ સાહેબ.
my lords.
મારે compulsory આવવાનું.
ના ના સાહેબ subject to honorable court's availability. We may take our chance or
My-
on any other day.
My lords,
But
just
it can be kept on this Wednesday.
on this Wednesday, my
But-
lords, we are ready with the matter.
That does not, please pass this order because every day, my lords, this
My
is a
lords-
question of 30
એક
lakh
સેકન્ડ
children.
એને બોલવા દે.
My lords, our request is let us go step by step. They may prepare the provisional merit list. The only problem that we might have in future if we qualify and succeed in the matter is that there are 11,000 posts and 11,000 schools. We will not get a post of my choice. With 700 posts will they keep vacant? If tomorrow the merit shuffles, they'll have to reshuffle everything. We are not here. We will not say that we will not argue the matter. But my request is let us go step by step. First, let them prepare provisional merit list. They may not prepare my list. Whatever past candidates are there, they may prepare a provisional merit list because this weightage will have to be given to them as well. So once that exercise is over, then the issue of giving appointment orders and selecting schools will come. So provisional merit list may be prepared, my lords. There is no bar. And meanwhile, my lords, on any convenient date, we are here before this honorable court. I have also prepared a chart of the relevant questions for the convenience of my lords. The questions that we have challenged, we can put an end to this. My lords, here, when my learned friend was arguing, he said that the questions where there were certain typing mistakes have been corrected. My lords, may kindly see the first question. Question number
Let me
148.
take up on Wednesday.
Please, my
Wednesday.
lords.
Please note.
Oblige, my lords.
Since my two matters are not coming, I'll make a request tomorrow to the online.
Do it.
I'm open.
Oblige, my lords.
36 and 30.